Is recognized for 5 minutes.
Thank you very much, Madam Chair. I would like to seek unanimous consent to submit to the record a New York Times reporting on arbitration entitled "Arbitration Everywhere: Stacking the Deck of Justice." What we're seeing here, and I'm interested in the interplay between everyday people, everyday consumers, and arbitration clauses. The arbitration clauses that are tucked in everywhere from whenever you sign a credit card or a debit card. It says here, even in the report on page 5 of a credit card contract used by an American Express, beneath an explainer on interest rates and late fees, past the details about annual membership, is a clause that most consumers probably miss. It says that the company may, quote, elect to resolve any claim by individual arbitration. Now, a lot of folks, to just clarify for the general public what an arbitration clause is. Arbitration clauses have been used, would you say, Mr. Gregg, that arbitration clauses have been used to circumvent the courts on a wide range of issues?
Correct.
Of potential misconduct?
Yes, so it's used against workers when it relates to sexual harassment or discrimination, wage theft. It's used in the consumer context when you have a dispute over your credit card or a student loan.
So if you're a company and you tuck this clause into virtually anything that you can make an employee or a consumer sign, whether it's a credit card agreement, whether it's an employment contract, you can essentially absolve yourself from almost any form of corporate misconduct. Is that correct?
That's correct. That's what will happen.
I find this extremely concerning that you can almost, before misconduct happens, already waive your right to seek justice in court. In fact, William G. Young, a federal judge in Boston who was appointed by President Reagan, said, business has a good chance of opting out of the legal system altogether and misbehaving without reproach. Would you agree with that, Ms. Lubin?
I think thank you for the question, and I think the way that pre-dispute arbitration clauses have developed in the brokerage business, that's what's happened.
Thank you.
I did.
I'm sorry, I just have to reclaim my time very quickly, but thank you. So you would agree?
Yes.
Mr. Gregg, I'm interested here in the wider impact. We're talking about not just issues of discrimination and worker abuse, but even on a macro level or potentially macroeconomic level. In fact, a federal court now is allowing a lawsuit by Exxon investors to move forward. Investors claim that Exxon knew and kept secret for years internal reports showing that they knew climate change and they knew that climate change was real and that the fossil fuels and their role in producing fossil fuels contributes to the role of climate change. Yet, they undertook a misinformation campaign to hide those internal findings and reports, including lying to their own shareholders. Mr. Gregg, are you familiar with this lawsuit at all?
I am.
So I have a question here. If we do nothing about forced arbitration and allow this practice to continue, could this mean that information about how companies are deceiving the public about issues like climate change or any other could remain hidden from the public and public scrutiny?
It could if we don't pass right now we can, currently shareholders are allowed to go together, to band together in a class action, but there are attempts to stop that. So that's why it's important to pass laws to protect.
So you would recommend that we support the legislation that we're entertaining today on investor protection to make sure that shareholders can be protected as well?
I would, because if we don't do that and the SEC reverses its policy, for example, then systemic issues would be able to be hidden and you would never be able to find out about these things.
And even on a macroeconomic level, beyond the justice of it, beyond making sure that shareholders that have been damaged by this deception and misconduct can recoup their costs via class actions, do you think that this has overall consequences for market integrity? So much of our macroeconomic and to make sure that we have a sound market depends on us trading on the truth. And if forced arbitration can prevent the public from knowing the truth about issues, it means that the values of many different industries could be manipulated and seen as more valuable than they are. Would you agree with that?
I would agree.
Thank you very much.
The gentleman from Illinois, Mr. Foster, is recognized for 5 minutes.
Thank you, Madam Chair, and thank you to our panel. Mr. Gregg, as you know, some commentators have argued that public companies should be allowed to insert forced arbitration clauses in their bylaws, which would obviously prevent shareholders from suing the company in federal court for violations of the security laws, including securities fraud. It would also prevent shareholders from bringing class action suits against the company for securities fraud. And can you just tell us in general terms why it's important for shareholders to be able to join class action lawsuits against public companies? And secondly, could you give some examples of class action lawsuits for securities fraud that have been successful for shareholders?
Mm-hmm. So on your first question, it's important for two reasons. The first is that people, as Professor Coffey said, people are not going to go in it alone. They just won't. They don't understand the process. They sometimes won't receive any help because attorneys won't be able to represent them, because if you're cheated $100 or $200, that's a lot of money, but it's still not enough to hire a lawyer to go to